Every courtroom keeps records. Every verdict gets filed. Every case leaves a paper trail that proves what happened. That's what they teach you. It's a lie. Some trials vanish completely, not sealed, not classified, erased. Names scrubbed from dockets, transcripts pulled from archives, whole cases that officially never existed. Sometimes the powerful make their problems quietly disappear. Sometimes the state buries its own mistakes. And sometimes the truth gets wiped so clean that even the people involved start doubting their own memories. Today, you're going to hear about 10 of those cases. Grab your coffee. This one's going to unsettle you. Number 1. The Standard Oil antitrust case that vanished twice. In 1911, the Supreme Court ordered Standard Oil broken into 34 smaller companies. What most people don't know is that key evidence from the original trial, internal memos detailing how executives bribed judges and destroyed competitors, disappeared from federal archives within a decade. Court historians confirmed the files existed, lawyers cited them in later cases, but when researchers went looking in the 1920s, entire boxes had been pulled from the shelves. The docket numbers remained, but the documents inside were gone. Someone with access had quietly cleaned house. The company was broken up, sure, but the full record of what they actually did? Erased before it could become permanent history. Number 2. The Teapot Dome cover-up beneath the cover-up. In 1924, the Teapot Dome scandal exposed government officials taking bribes to lease federal oil reserves. Secretary Albert Fall went to prison. Headlines ran for months. But here's what the newspapers missed. A parallel case involving a sitting United States senator was filed, heard, and then completely removed from Wyoming District Court records. Historians found references in private letters and newspaper fragments, but the official file simply doesn't exist. No transcript, no verdict, no explanation for the gap. The senator finished his term and retired quietly. Somewhere between the courtroom and the archive, an entire trial was made to disappear. Number 3. The witness who won and then lost everything. In 1953, a factory worker named Samuel Hendricks testified against his employer in a workplace injury case in Ohio. He won. The jury awarded him $12,000, a life-changing sum at the time. 3 months later, Hendricks tried to collect his judgment. The court claimed no record of the verdict existed. His lawyer's copies were dismissed as fabrications. The company's attorneys produced a blank docket entry where his case number should have been. Hendricks spent years trying to prove his own trial had happened. He died in 1967, still fighting. His family found the original jury summons in his belongings. The court never acknowledged it. Number 4. Juvenile expungement factories. Starting in the 1950s, several states adopted policies allowing juvenile records to be expunged after defendants turned 18. Sounds reasonable. In practice, it created a system where wealthy families could erase serious crimes, assaults, thefts, even vehicular manslaughter, while poor defendants often never learned expungement was an option. Court clerks later admitted that certain judges approved erasures in bulk for connected families, sometimes without any hearing at all. The records weren't sealed, they were destroyed. Entire filing cabinets shredded on schedule. What began as mercy for youthful mistakes became a quiet machine that memory-holed violence when the right people asked nicely. Number 5. The civil rights case that helped no one. In 1962, a group of black voters in rural Georgia filed suit after being turned away from polling stations. They won. A federal judge ruled the county had violated their constitutional rights and ordered new registration procedures. The victory should have set precedent. Instead, the case was sealed at the request of local officials who argued publication would cause unrest. 20 years later, when activists tried to cite it in a new lawsuit, they found the seal had become something else entirely. The file was gone. Court staff said it had been lost during a building renovation. No backup existed. The voters won a case that, officially, never happened. Number 6. The pharmaceutical settlement no one can find. In 1987, a major drug company faced a class action lawsuit after one of its medications caused severe birth defects in dozens of children. Internal documents showed executives knew about the risks and suppressed the data. The company settled quietly for an undisclosed sum, and the case was sealed. Standard practice. But when journalists requested the docket in 2004, the court reported that all records associated with the case had been purged during a routine archive cleanup. No plaintiff names, no settlement amount, no admission of wrongdoing preserved anywhere in the system. The company continues to operate today. The families received their money and signed non-disclosures. The proof of what happened exists only in the memories of people who were there. Number 7. The journalist who found the file and lost her career. In 1994, a reporter named Catherine Walsh was investigating corruption in a Midwestern police department. A source slipped her court records from a 1986 case where officers had been charged with evidence tampering. The charges were serious. The documentation was thorough. But when Walsh contacted the courthouse to confirm details, she was told the case didn't exist. No record in the system. She published anyway, using the documents her source had provided. Within months, the newspaper retracted her story under legal pressure. Walsh was fired for fabricating sources. The officers she'd named sued for defamation and won. She spent the next decade trying to prove the records had been real. In 2011, a retired clerk admitted in a private letter that the file had been pulled on orders from the county prosecutor. By then, Walsh had already died. Heart attack at 53. The story she tried to tell remains officially false. Number 8. The death row case that proved innocence too late. In 1978, a man named Robert Colvin was convicted of murder in Texas based largely on eyewitness testimony that later fell apart. He maintained his innocence for 14 years. In 1992, a law student found trial transcripts showing the prosecution had withheld evidence that pointed to another suspect. She filed an appeal. 2 weeks before the hearing, the courthouse reported that the original case file had been destroyed in a records purge. No transcripts, no evidence logs, no jury instructions. The appeals court ruled there was nothing to review. Colvin was executed in 1993. 3 years later, DNA evidence from a related case identified the actual killer. The man who'd been executed had been telling the truth. But without the original file, there was no official record to correct. Robert Colvin remains legally guilty of a murder he didn't commit. Number 9. The file that resurfaced for one day. In 2003, an archivist in Nevada discovered a misfiled folder containing complete records of a 1971 case involving a state senator and allegations of bribery. The file had been marked for destruction decades earlier, but somehow survived in a basement storage room. She reported the find to her supervisor. Within 24 hours, lawyers arrived with a court order to seize the documents. The archivist was told the records were part of an ongoing investigation and couldn't be discussed. She never saw the file again. When she checked the database the following week, the case number had been reassigned to an unrelated traffic dispute. The original entry was gone. She filed a complaint with the state records office. It was dismissed without explanation. Number 10. The algorithm that decides what stays. Today, court records aren't stored in filing cabinets. They exist as data on servers managed by private contractors. In 2019, a transparency organization discovered that one of the largest court record management companies had quietly deleted over 40,000 case entries across 12 states. The company claimed it was routine maintenance. Researchers who examined the gaps found a pattern. Cases involving corporate defendants, government agencies, and wealthy individuals were disproportionately affected. No court had ordered the deletions. No judge had reviewed them. An algorithm had simply decided which records were worth keeping. The company faced no penalties. The cases remained gone. The frontier of erasure didn't close. It moved from dusty courthouses to server farms, from filing clerks to automated scripts. The tools changed, but the principle stayed the same. Whoever controls the archive controls what officially happened. Paper could be shredded. Ink could fade. Data vanishes without a trace, without anyone knowing it existed. If you made it this far, you're looking at the legal system differently now. That's the point. Next time someone tells you courts keep perfect records, remember Samuel Hendricks waiting for a judgment that no longer existed. Remember Catherine Walsh dying before anyone believed her. Remember 40,000 cases blinking out of existence because an algorithm said so. Tell me which case hit you hardest. Subscribe and stick around. Next time, we go deeper into systems that shape what you're allowed to know. The records say what someone wanted them to say. Now you know that too.